All right, everybody, in the interest of starting on time, let's go ahead and get going. For those of you who don't know me, I'm Professor Tonya Kowalski. I'm a faculty member here at Washburn Law. Welcome so much to the afternoon session of this fantastic symposium, and thank you, we can't say it enough, thank you to the staff and students who were really behind this effort for putting on such a great, putting together such amazing panels and making this event so special. I would like to just very briefly introduce to you our panel members for this next session, which is entitled Legal Reasoning in the Age of Alternative Facts. I can't do them justice because I want to make sure that they get the benefit of the time and I'm not up here blabbing too much. So I'll just very briefly introduce them to you, but please know that their accomplishments are extensive, and I invite you to visit their bio pages to see everything they've been up to and to follow their research so that you can stay on top of these topics as they come out. All right, so first introducing to you Joy Kanwar. Joy is a professor of legal writing at Brooklyn Law School, and she previously practiced with Skadden Arps. She was in the area of complex mass torts as well as a number of other really high-level areas of law practice, and also has a special interest in environmental law. And we welcome her today. Thank you so much for being with us. Cathren Koehlert-Page is a faculty member at University School of Law. She has a special practice experience and interest in child protection law and also in applied legal storytelling, which is one of the fields of expertise she'll be drawing on today. Teri McMurtry-Chubb is a professor at Mercer University, Walter F. George School of Law. She publishes so profusely in so many fields I can't even possibly describe to you all. But she is, one of her most recent works is called Say Her Name, Black Women's Lives Matter, State Violence in Policing the Black Female Body, that just recently came out in 2016. Among her other professional accomplishments, and this was astonishing to me, she was the first person of color ever to be hired at her law firm in Iowa, and one of only 2 African-American women in the entire state of Iowa in private practice at the time that she was in private practice. So we welcome her as well. Teri is also a past president of the Association of Legal Writing Directors. And finally, Ann Mullins, last but not least. She's a faculty member at Stetson University College of Law. She is a president-elect of the Association of Legal Writing Directors, and her scholarship examines judicial writing through a cognitive theoretical framework. Welcome to all of our panel members, and without further ado, I'll let you proceed.
I'm going to use this mic because I kind of like to move around a little bit. So this is a paraphrase from an American president. The press has spread more lies in the last 10 years than in 100 years. Sound familiar? Sound like a president you know? The actual quote is from John Adams in 1798. There has been more new error propagated by the press in the last 10 years than in 100 years. And I think this gets to what other people have been saying today, that people have pre-existing beliefs that are shaped by the cultural narrative, by their values, and then later they use facts and logic to justify their beliefs. Even in a true story, it's important that the story have a sense of reality. Stephen Colbert might call that truthiness. Novelists call it verisimilitude. Verisimilitude is this air of reality weaving in concrete details so that it seems as though it could be so. It could have happened. And so earlier today, we mentioned alternative facts. And perhaps some of you remember when Kellyanne Conway went on Hardball with Chris Matthews, and this was just after the first Trump travel ban, and she was saying, oh, well, you know, Obama had some of these same countries on a list as well. which was a concrete detail that she wove into her narrative. And she said there were 2 Iraqis who came here and were radicalized, and this is another true, concrete detail that she wove into her narrative. And then she said, and they were the masterminds of the Bowling Green massacre, which never happened. But I think for Trump's base, what was important was that it had mythic truth. That they looked at it and they thought, well, she got the details a little bit wrong, but it could have happened. That it could have happened can be so persuasive. My late mother read a lot of novels, and she used to say, oh, well, she'd be justifying some viewpoint, and she'd say, oh, well, there's a book about that. It's fiction, but they research these things. And I know, we can all sit here and I laugh at my silly old mother. And at the same time, if you look at an opinion or a law review article or sometimes even an oral argument where there's an open question of law, what do we tell people to do? What do we see them doing? We tell them, talk about the policy consequences, the effect of this or that interpretation. And so we see these fictional dystopias then giving justification for why we may choose this interpretation or that interpretation based on something that has not happened yet. So already fiction has played that sort of role in law. Likewise, untrue facts have often been a part of our cultural landscape. So even the medical profession used to frequently diagnose women with hysteria, which is part of the cultural narrative that, we're too emotional. And it's for this reason, along with others, that women shouldn't be allowed to vote or serve on juries. And then you'd see similar justifications given for why Black people or immigrants should not serve on juries, that, they're too emotional. And it was after women and Black people began serving on juries that we then had an amendment to the rule of evidence, or amendments to the rule of evidence, and we saw an introduction of Rule 403, which said that you could prohibit evidence if the probative value was outweighed by unfair prejudice. And often in the cases that you see on Rule 403, they talk about, it's too emotional. We can't trust the jury with this, which I think taps back into what John Campbell was saying earlier today about trusting juries. So, untrue facts have often played a role in both our legal and political narratives. One of the things that's actually different today, however, is that we have greater medical knowledge, greater scientific knowledge, greater psychological research, and we have technology at our fingertips. So before the invention of the photograph, a president could have said, well, this was what my crowd size was, and it would have been his word against the word of the other people there. Now, if Sean Spicer says that was the largest audience to witness an inauguration, any school child can Google and see the actual photographs. And so we do have this fact-finding mechanism. I know some of us might have watched the Kavanaugh hearings and thought, he got up there and he said, "Boff means fart," and we're supposed to buy that. He said various things that were impeachable, that later people in the press impeached. And I think there's this fear that that's what our legal narratives are going to become, because this was at that time a Supreme Court nominee. He's now serving on the Supreme Court. But the thing is, that was a Senate hearing, we didn't have the same kind of fact-finding process that you have in an actual trial. We didn't have the same kind of discovery process. Still, our law students will have that fact-finding process available to them. Still, they must introduce sworn testimony and authenticated exhibits. Still, they have to cite to the record if they're on appeal. And so we do still have a means for getting at the true facts in law. Perhaps even greater means than we once had because of all of our technology and all the new scientific information we have today. So what do we do, though, when we see untrue information being propounded or various unfair narrative strategies being used, or even maybe fair strategies that sort of play with our perception and bias? I played with perception a little bit today. That very first slide, did anyone notice I had a Twitter background? I paraphrased it so it wasn't in the same old language. So that was a little bit of misdirection there. So I think this is something that Anne is going to talk about a little bit more on the panel today, is that one of the things that we can do, and this gets back to what Dr. Strong said in her first presentation, is that the more you start recognizing these things, and I think it also gets back to what Kara Kenningham said earlier today, the more you recognize these things, the more each of us can start looking at our own biases. So if you start labeling techniques, as long as we've been teaching reason, certainly we've been teaching logical fallacies, and that's something that we'll continue to teach to law students. We all also now have new psychological strategies that we're able to label. When someone is trying to say that an untrue fact is true, or that it didn't happen that way when we know it did, we call that gaslighting. When somebody is trying to take something that could be a crime and say, oh, this is just ordinary behavior, we call that normalizing. When somebody tries to blame the victim, we call it victim blaming. And so just learning these labels can help us weed out our own biases. Learning also the persuasive strategies. So for me, certainly I can get emotional about some of these narratives myself, but the past 2 years I've been studying the Trump narrative in my past article and the other one that I have upcoming. And so I've been studying persuasive techniques, and when you're stepping back to look at the techniques being used, which is what we do in an LRW classroom, and we're looking at two different sides of an issue, and we're looking at the techniques, that sometimes takes the emotion out of it and helps to filter through our bias. And so one of those techniques is starting with the protagonist and giving people a protagonist that they can identify with. And so George Lakoff, who wrote Don't Think of an Elephant, he talks about how people don't vote their beliefs, they vote their identity, which gets back to this same idea. Donald Trump, in his narrative, what I found is that he uses a lot of superhero fiction techniques. And one of the things that I think he's successfully done is that for a large swath of his audience, he has coded himself as being on his audience's team. So he puts on this cap and repeats the word jobs over and over. And that repetition has sticking power. When somebody repeats something, it does stick in people's brains. That's another thing that Lakoff has studied. And so people look at him and they say, oh, he's on team jobs, he's on my team. And then he has this other part of his uniform that says, I'm on team business. Well, this is actually a technique that was used in early superhero fiction. It came during a time of war. And you can see that the superheroes were wearing red and blue, sometimes white, sometimes stars, showing the audience, I'm on your team. I'm on Team America. In using these techniques, we want to teach people to still be honest. It's possible to use narrative techniques with a nonfiction narrative, and they can be applied by both sides. So, for instance, Doug Jones in the Alabama Senate race, which was a historic race, first time that Alabama voted for a Democratic senator in a long time, he successfully showed his audience, I'm on team equality in terms of establishing his identity. He, over and over, you would hear Doug Jones successfully prosecuted the KKK. An example from a legal case, U.S. versus Brown, it's a search case. And the court, in its opinion, they talk about how Richard Brown is walking home. He goes up the stairs of his apartment. He looks in the window, and he sees pointed at him a gun. And the stranger holding the gun said, "Don't move. You're under arrest." And so the way they started that story, Richard Brown is any one of us as we're walking home, as opposed to Richard Brown, the criminal defendant. So they started with an identity that was more universal. And so that kind of universal identity may be one way of persuading people with a narrative. I've gone through in the article itself and discussed other types of narrative techniques that you typically also do see in superhero fiction, and have shown how they've been used in different campaigns, as well as in litigation. I think the important thing is that, A, we realize that once we learn more about these techniques, we can start to spot them. And we can start to see when somebody is using these techniques on us. And B, that sometimes they can also be tools in our persuasive toolkit. Okay, so.
Thank you so much, Professor Koehlert-Page. Our next panelist to speak will be Professor McMurtry-Chubb. Yes, of course.
All right. Can everyone hear me? So, thank you. So I've been living in the South for a long time. I'm not a grit girl raised in the South, but I do have manners. So I want to thank the Robert J. Dole Center for Law and Government, the Washburn Law Journal, and the Center for Excellence in Advocacy for having this symposium. Dean Carla Pratt, Associate Deans Joe Mastrosimone, Dean Sean Lysinger, and Jeffrey Jackson, and Professors Tonya Kowalski and Emily Grant. You all don't know this, but Washburn is one of the most special places on the planet, and you have some of the best faculty in the world. I feel comfortable saying that. And they are some of my favorite people on the planet, so I'm happy to be here. I come from a tradition that uses call and response, so I want you to repeat after me. The arc. Oh, you can do better than that. The arc of the universe will not bend toward justice unless I bend it. So I want to talk to you about civil rights on a micro level. And part of the work I'm going to talk about is an empirical research project that I've been doing for about 6 years. So the work of critical rhetoricians and social scientists have shown us that how a person interprets facts, or even what they consider to be a fact, is dependent upon the knowledge bases that they draw upon that shape what they know. The fancy word for that is epistemology. How do I know what I know? And who they are and how they become who they are, which is ontology. Those are the only two 50-cent words I'm going to use. Both epistemology and ontology are shaped by identity and positionality, meaning how I see myself and the position I find myself vis-a-vis certain people and certain situations. So when a person is an attorney tasked with drafting a legal brief, a document of persuasion, where one of the parties is a minority and the issues revolve around difference, the attorney's identity and position can have a detrimental effect on how they interpret facts and then how they select the applicable legal standards by which to evaluate those facts. So what I want to talk to you about simply today is disruption. We've been talking a lot about how you recognize when you have biases, and we've been talking a lot about implicit biases, which makes me laugh because where I'm from in the part of the country, we're way beyond implicit bias and way into explicit at this point. And so my task here today is to talk about how do we disrupt and course correct. So again, I mentioned that I've been doing this empirical research project, which I'm in the process of writing up. Part of it I'll write up for the law review, on the relationship between racism, sexism, classism, and homophobia, and how law students formulate arguments in brief writing. So what I've done is I've looked at student briefs that I have created over the past 6 years, case files. And so I'll just give you a little overview of some of the case files I created. A hostile work environment claim based on same-sex harassment of religion and national origin. A Muslim American male was harassed at work by a white male on or around the anniversary of 9/11. The Indian Child Welfare Act, a case involving the adoption of Indian triplets by an African American family. The admissibility of rap lyrics in a criminal trial, hostile work environment claim based on colorism and racial harassment. Let's see here, freedom of expressive association claim brought by a student organization at the law school. They're actually an LGBTQ advocacy group called Radical Rainbow Justice. That's kind of one of my favorite problems that I give the students. And then the project I'm going to talk to you about today, or the case file, is a challenge to a law school legacy admissions policy on grounds that the legacy admissions is a racial preference or affirmative action for whites. So the big empirical research project involves 192 students and 384 papers over the course of 6 years. And so the case file I'm going to talk to you about today was one I gave in fall of 2017, and it's on legacy admissions and affirmative action. So why did I choose to create this case file? I'm a writer. My friends always laugh at me, as you saw, they were kind of tongue-in-cheek, like, Teri's always writing. But I'm a writer, like, first. That's how I identify myself. So I create these elaborate case files where I research, like, the fictional places where my people are going to live, down to the apartment. Like, I look at vacant apartment listings or vacant houses, depending on where they need to be. And the students really sometimes have and I create, like, deposition testimony and trial testimony. And the students really sometimes think that these are real people. Like, they'll come to my office and they'll be like, so how's Monk Jenkins? Like, is he in jail? And I'm like, he's like fake. And they're like, what? I don't know. So over the years, I have been really concerned about the racial rhetoric about who belongs in law school and who does not. Often expressed as somebody took somebody else's seat, and the somebody who took the seat looks like me, and the somebody whose seat is taken does not look like me. And so framing student admissions this way is detrimental to student emotional and psychological well-being. So I have a lot of my students come in and they talk to me about the sense of not belonging and how that impacts how they participate in class, interact with their colleagues, how they feel. And so I've been, this has been in the back of my mind. I said, you know what, I'm going to really try to challenge this and see what we come up with. So of note in particular is stereotype threat, or when people of color feel that if they fail in some way that they're going to confirm every single negative stereotype that people might have about them. This is a real phenomenon. So the case file at issue is a fictional law school located in West Virginia. I picked West Virginia because of the last census, 93.6% of the population was white. The law school is a state land grant institution and must accept the majority of applicants, 60 to 70%, from West Virginia. Residency usually equals less stringent admissions criteria. Accordingly, a disproportionate amount of admitted applicants are white, and the majority of those reside in the state. Additionally, weight is given to legacy applicants. So because of the admissions policies and the state demographics, the majority of legacy admissions are white. Legacy admits, in my case file, have lower GPAs and LSAT scores than any other category of admits. So for this case file, I produced, I think, 7 years of admissions data, as well as the guidelines given to the admissions committee. So the students had all this data to crunch. My plaintiff, his name is Xavier Benton. He's an African-American male, and he's a resident of West Virginia. He is not a legacy applicant. At the time he applied for admission to the law school, he was employed as a biomedical engineer with the company MedImmune. Xavier graduated, and MedImmune does exist, by the way. Xavier graduated with honors from the chemical engineering program at Howard University. Shout out to Dean Pratt. He was attracted to the law school because they had a national recognition in intellectual property, which is what he wanted to go into. He had a 3.75 UGPA, which was in the 75th percentile of all applicants in the law school admissions pool, and he had a 168 LSAT, also in the 75th percentile. He was not granted admission. Subsequently, Mr. Benton sued the university. I will let him know. In essence, his argument is that somebody took his seat and that somebody was a white legacy admit. So the legal universe comes from Bakke and its progeny. And what I want to touch on basically here are 2 items that the students had to grapple with, and then from the case law, draft their legal arguments. So if you read Bakke and its progeny, you know that Bakke is concerned with racial quotas and racial classifications used in special or race-conscious admissions policies. You all follow me? Okay. So first, race quotas. Bakke tells us, and its progeny tell us, that white can be a racial classification. And Bakke, in its opinion, goes on to talk about how the terms majority and minority changed based on historical context, so it would be unfair to fix one group in time as a minority and one group in time as a majority. But the takeaway for us here today is that white can be a racial classification. The second thing about Bakke that I want to touch on is racial classification when used in a race-conscious admissions policy. So Bakke tells us that a university can use special admissions or race-conscious admissions policies to achieve diversity. The question for my students, though, when we're dealing with legacy admits who are white is, can the state use a classification for a different end other than diversity? Furthermore, if the state uses a racial classification, in this case whiteness, in legacy admissions, it must show that its purpose in doing so is substantial and that the classification is necessary to achieve its purpose. Absent these findings, a state's purpose is neither compelling or substantial. We know that diversity is a substantial interest. Can maintenance of wealth be a substantial interest? So my reason for crafting the universe this way was to get the students to think about, what does all of this reveal about race-conscious admissions as it applies to white people as a historically non-disadvantaged group? So if we're talking about legacy admits, how do we justify this if we look at it as a group, as whiteness as the racial classification, excuse me. So students draft a motion brief first, and then they draft an appellate brief. So they draft a motion brief, which would have been the initial injunction, right? Mr. Benton saying, hey, you should admit me. And then they draft a brief on appeal after the learned judge renders an opinion. So my preliminary review of the student briefs reveal that each student's ability to make effective, persuasive arguments for the party is directly related to their assumptions about race, class, gender, sexuality, and sexual orientation of the parties. So for our particular problem that we're talking about today, race-conscious admissions, legacy admits, the brief showed that all of the students at the motion brief stage read racial quota as only pertaining to racial and ethnic minorities, not to white people. So for them, white people could not be beneficiaries of a racial quota system because whiteness was not a race. Furthermore, students in the class were overwhelmingly reluctant to see legacy admissions as a racial classification for whites under the Equal Protection Clause of the United States Constitution, even though in excess of 90% of the legacy admins in a 7-year time period were white, and the controlling legal authority explicitly stated that whites could be a racial classification. The majority of student work product cast the race of the African American student, the plaintiff, Xavier Benton, as the racial classification. So when students came into my office with their motion briefs, and they're all happy with their little arguments, they were like, I got it. Mr. Benton, he's wrong. And I said, he's your plaintiff. Like, he's bringing the lawsuit. And they're like, well, his blackness is at issue. No, it's not. It's not. So we had to have these kind of conversations. So getting to what I promised, disruption. How did we disrupt this? At the point where students were bringing in their motion brief drafts, we did 3 things. Secondary sources on legacy admissions as racial quotas and race-conscious admissions for white people. So I had them listen to blogs, and there were these wonderful articles coming out on the Harvard website on admissions and legacy admissions. And so they got to read something that I didn't produce, right? So they're like reading these sources from other people. Live client interviews. What I do is I bring in people from the community who are not actors, who actually do the job, and the students get to interview them. So I brought in our development people and our alumni people, and for them to ask the question, is there a direct correlation between legacy admissions and increased donations? And both my legacy people, both my development people and alumni people said, no. We hope so, but no, which blew the students' mind. So in individual student conferences, after they had been exposed to all this information, they came in, and an interesting thing started to happen. Number one, they had skin in the game, but number two, actually having to work through a problem created empathy in them. So I had students that were coming out to me as legacy admissions and beginning to critique how they were admitted to the law school. Most of these students were white. And so they would come into my office, and it would go something like this: Professor MC, you know, when I applied, I got in like a week later, but my dad went here and so did my granddad, so I guess I'm a legacy admit. And now I don't know if I deserve to be here, because I'm looking around the room and a lot of people seem to be more qualified than I am. Huh, okay. Questioning their belonging was a powerful turning point in how they were able to think through the law and to recalibrate the arguments they were going to make. So after this initial disruption and motion brief grades are in, they do their appellate brief, there's this immense course correction that occurs in the appellate briefs where the students are making arguments in line actually with the legal authority. So they're able to see the actual racial classification, whiteness, and the kinds of questions that they need to be asking of the legal authority. But what is even better is that the students are deeply engaged in the subject matter from that point on, and so we've been able to have these very meaningful conversations about the subject going forward. So for instance, with the Harvard case coming out, I have students emailing me who are not even in my class anymore, and you know, I guess the trauma of writing is gone for them at this point. But they're like, Professor MC, are you following the Harvard case? No, why would I? Yes, of course I am! And then they say things like, oh wow, so these are the arguments I think the lawyers should be making. And they're making some really sophisticated arguments, and they're like engaging with me. They're looking at the pleadings in the case. They're pulling things. And so I leave you with this, that my research project and what it reveals has the potential to change how we view the preparation of law students for law practice. As such, it has sweeping implications for the study of diversity in the law. Legal education touts diversity, equity, and inclusion as aspirational goals, but looks at it from the admission standpoint and not what we're doing curricularly necessarily in our classrooms. So if we tackle how hierarchies are reproduced in the very pieces of, or the very documents, the very genres that are used to make up our fabric of law, then I think we might be onto something. So the arc of the universe will not bend toward justice unless we bend it. Thank you.
Thank you so much, Professor McMurtry-Chubb, Professor MC, and I welcome Ann Mullins to the podium. Welcome, Professor Mullins.
Thank you, Professor Kowalski. And thank you to the Washburn Law Review and to Washburn for hosting us today. I want to talk about football. In 1951, one of the most contentious games of football in the Ivy League was played. It was Dartmouth versus Princeton. And things devolved pretty quickly with rough play, lots of penalties, contested calls. Princeton's All-American quarterback left in the second quarter with a concussion and a broken nose. Dartmouth's quarterback left in the third quarter after a hit in the backfield with a broken leg. So, what does the 1950s football game have anything to do with what we're doing here today? As you can guess, it turns out a lot. About a week later, 2 psychologists sent out surveys to students who had seen the game. And they asked questions like, who started the rough play? Was the game clean and fair? And what they found was that student responses largely split based on school affiliation, with the Princeton students giving pro-Princeton responses and the Dartmouth students giving pro-Dartmouth responses, right? And a few years later, these same psychologists showed a film of the game to Dartmouth students and Princeton students and tasked them with the duty of counting the number of penalties the Dartmouth players made. The Princeton students counted twice as many penalties as the Dartmouth students. The student school affiliations created a lens through which they perceived the same football game. There was a football game, and it appears that there were many football games, right? So what lens the identity or their connection created deeply impacted their perception, and as the old adage goes, perception is, of course, reality. So we've always lived in an age of alternative facts. So what I want to do is use the rest of my time today to make 2 observations, explore 2 different points. One is litigation, and especially litigation over fundamental constitutional rights, is increasingly reliant on empirical data about the way the world works. How lawyers and judges perceive that data, how they consume it and how they use it, has potentially far-reaching implications. And number 2, law school curricula have not adjusted to this new legal landscape and are not adequately preparing students to go out and litigate in this new legal landscape. Law schools should better prepare students. We can do it, and I'll offer 2 modest proposals how. So going to my first point, how people perceive facts has always been important in litigation, right? But the landscape over the last several years has shifted, particularly with respect to litigation over fundamental constitutional rights. And as Professor Allison Orr-Larson explains, litigation over fundamental rights is becoming increasingly saturated with legislative facts, right? And when I say legislative facts, I mean facts about the way the world works, right? So answer to the question of is abortion safe? Or how prevalent is voter fraud, right? And judges are using this empirical data to reach and to justify far-reaching decisions on constitutional rights. And, judges are not only using this data, they're requesting it. They're asking for it. They're relying on it. And when litigants and amici don't give it to them, you know what they do, right? Come on, somebody. Google, right? Like, that's what they do. They hop online. And if they don't do it, they go tell a clerk to do it. And then they use that data how they want to use it. So the increasing impact of empirical data in litigation raises 2 pretty serious issues. Number 1, judges are not formally trained in empirical methodology. So they are not well set up to scrutinize the empirical data that they're using and determine what is junk and what is not. Their clerks aren't trained either. And compounding this lack of training issue is that we've got the perception issue, right? And the perception issue is that people from different cultural communities are reacting to empirical data in different ways. So in other words, people who might agree on abortion and school prayer also agree on whether genetically modified foods are safe, right? So getting back to Dr. Strong's talk this morning, this is sort of where we have the data conflict and the values conflict kind of coming together in a perfect storm. And so the problem is, in Professor Dan Kahan's words, America is involved in a culture war over empirical data. We need to know the reason why, given the increasing impact of empirical data in litigation over our fundamental rights. And that means we need to turn to cognitive theory, which tells us, among other things, what influences us, what persuades us, right? And in a nutshell, there are thousands and thousands of studies that show us what influences us and what persuades us. And back in 1984, Professor Robert Cialdini, who Cass Sunstein and Richard Thaler called the great guru of social influence, back in 1984, Professor Cialdini kind of looked at all these studies and he organized them into sort of 6 principles of influence, okay? The one that I think is most relevant to our what we're talking about here today is what Cialdini called liking. We are influenced by, or we tend to be very persuaded by, people who we like. And while that might sound subjective, scientists can predict who we're going to like based on certain factors, right? And one of those factors is similarity, right? We like people who are similar to us. And like this can be similarity in the most ridiculous way, like having the same initials in your name, right? Having a similar fingerprint pattern, okay? So we are heavily influenced by those who are similar to us. In 2016, Cialdini added another principle of influence, and he called it the unity principle. And the unity principle is essentially liking on steroids, right? We are incredibly influenced by people with whom we share core identity, okay? At the same time, there was an interdisciplinary group of scholars who created something that's called the Cultural Cognition Project. This is what Dan Kahan is a part of. And they coined the term cultural cognition after they examined, they conducted studies looking at different group values and their impact on people's risk perception and resulting policy choices. And the group values they looked at were authority versus equality and individualism versus community. And yes, those do essentially shake out along like the traditional political lines, okay? And, you know, so what their argument was is that essentially it explains why people who share certain cultural commitments tend to approach empirical data in the same way. So, you know, we are emotionally predisposed to approach empirical data in a certain way based on whether it aligns with our cultural identity group or whether it distances us from our cultural identity group. So, you know, according to Cialdini and the cultural cognition scholars and others, this is why people who align on the cultural issues like abortion, school prayer, transgender rights, also tend to agree on like, is climate change real? Or is underground disposal of nuclear waste safe, right? So what does this mean, you know, for lawsuits that are jammed with empirical data regarding hotly contested cultural issues, right? Our core fundamental constitutional rights. Well, one of the things, you know, one of the concerns that it raises is that, you know, as multiple people today have said, you know, the people who participate in the legal system are human, right? And that includes judges. It turns out they're human. They are subject to the same cognitive biases that the rest of us mere mortals are subject to. I'm not aware of any specific studies that have examined whether or to what extent judges fall prey to cultural cognition or the unity principle specifically, but there are swaths of political science studies that link judges' purported or predicted political leanings to certain decisions that they have made. So, common sense suggests that, cultural cognition impacts at least some judicial decision making at least some of the time. So what we have is a landscape saturated with empirical data and untrained consumers of that data whose ultimate decisions are likely in part impacted by cognitive biases that affect their perception of that empirical data. Right? Like, that's not good. Okay? So what can we do to make it better? Well, I ascribe to the view that better input equals better output, and you'll see what I mean in a moment. I've got two suggestions. One is actual, in law school, actual training on empirical methodology. Lee Epstein and Gary King called for this back in 2003. They did this as their push was to make legal academic empirical scholarship better. But one of the observations they made in arguing for including empirical methodological training in the law school curriculum, one of their poignant observations was that our legal training and our jobs as lawyers really make us terrible consumers and purveyors of empirical data, because what we're tasked with doing is going out and marshaling a bunch of evidence to support a particular point and minimizing anything that's contradictory. And compare that to PhD students who are pushed to take their most favorite hypothesis, examine it, test it every possible way they can, hold it up and scrutinize it against the very best arguments against it, right? In 2008, there's a group of scholars who wanted to see, well, how much scientific training are law students getting? Who has heard, Epstein and King's call for more empirical methodological training? And what they came up with was that about 28 schools were offering courses in empirical methodology to law students. What their study doesn't reveal is whether these were required courses, when these courses were offered, whether they were capped. I'm looking at it now, okay? And what I have found so far is that very, very few law schools offer training in empirical methodology. And of those that do, the courses are all offered as electives in the upper level curriculum, and from what it looks like, they are all capped. So that means of the small handful of schools that actually offer the training, they are producing only a small subset of graduates who have had the benefit of that training. If litigation around our most sacred rights is going to be saturated with empirical data, then more than just a handful of students need training in how to, at a minimum, consume that data thoughtfully. In addition to education and foundational empirical methodology, law schools need to expand education in cognitive theory. Here's number one. This is, to me, basic lawyer literacy. Okay, law schools, and maybe this is our status quo bias, right? But law schools and the legal profession seem to cling to this idea that persuasion is something that's kind of like magical. Some of us have it. It's, you get it after watching great lawyers and you become really persuasive, right? Persuasion's not an art. It's a science, right? It can be taught, it can be learned. What I believe Professor Campbell said earlier, it's legal malpractice to not have some background, he said, in Dan Kahneman's Thinking Fast and Slow, that is ultimate, that is at its base, like cognitive theory, science of persuasion. I think it's educational malpractice for schools not to train students in the science of persuasion. But closer to our mission here today, cognitive theory helps lawyers create arguments that combat the distortions of cognitive bias, and that includes bias created by cultural cognition. So, for example, members of the Cultural Cognition Project have learned that when they present data in a way that affirms people's values rather than challenges it, makes people more open-minded when reviewing that empirical data. Members of the Cultural Cognition Project have found that when a member of your cultural identity group vouches for that data, you're more likely to approach that data with an open mind. They tested this by showing the authority individualist folks, a buttoned up, coat and tie white guy vouching for data that, on something scientific that is typically associated with progressive policies. And people were much more open to that empirical data presented by that person as opposed to the long-haired hippie guy that was dressed casually, right? The same was true on the other side, okay? And as Professor Strong pointed out, the Cass Sunstein has identified sort of the surprising validator theory, right? So you can move people to accept and be more open-minded about data when there is a surprising validator. Those of you who've been watching the Florida election results, Stetson's in Florida, so I have been watching them. You will know that in general, the Republicans edged out the Democrats in the big picture, with one exception, from what I can tell, in terms of statewide affecting. There's the smaller races. I'm talking about statewide stuff, but one of the ballot initiatives that passed, that is typically, associated with progressive policies and typically associated with rejection by, conservative policy groups, is restoring the right to vote for felons. Florida has now, it was one of the two most restrictive states. Felons couldn't, if you had been convicted of a felony, it didn't matter if you had served your sentence, you couldn't vote, period. Well, now you can. And given the way that the state broke down and voted, I think the surprising validator had an impact. Well, who supported this Felons Can Vote initiative? Well, the ACLU did, of course. The Freedom Project did, too. The Freedom Project is funded by the Koch brothers. My suspicion is that probably moved the needle, okay? So, taking the long view of our mission, how to encounter a world of law and alternative facts, taking the long view, an even better reason to educate students in cognitive theory is that emerging research shows that education in cognitive theory, and especially in cognitive bias, can mitigate the effects of cognitive bias, right? So in sum, better input leads to better output. If schools can release new law graduates into the world with foundational education in empirical methodology and in cognitive science, the justice system will be more effective and less prone to error and distortion. Thank you.
Thank you so much, Professor Mullins and Professor Kanwar. You're welcome to the podium.
Well, thank you all for being here and for staying to the end. I'm actually going to be pretty brief because I feel like every important thing that I wanted to say has been said. So we're going to maybe do it this way. I wanted to offer just a couple of quick sort of organizing thoughts, and then I wanted to actually see if you all had thoughts in terms of where we go from here and what we can do. in a law school setting. So first, I'd like to say, I'm not sure if Professor Strong is still here, but I was very, 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 very moved by her article when I originally read it. So I'd organized this, the piece that I'm writing for Washburn, but also this talk around responding to her article, which was, what is it that we can do as a community? So I thought that might be a good way to end our presentations today too. So the three arcs that we've talked about today as in our day together is basically why we believe things that are not true and that have been validated not to be true, but then we continue to hold them to our heart. And I think that the idea is that we identify with who we are, and that is the truth. And so if that is the case, why do we do it, and what can we do about biases? So that's been one big theme. So taking into a deeper dive into why we don't challenge falsehoods, and we particularly don't care to. Well, a lot of the science actually shows that this has started from childhood. I mean, this is not, we don't all spring fully formed from the head of Athena. We were children at one point, and then we grow to adulthood. So we start with ideas of challenging norms and concepts, but we often find ourselves just disengaging as children. So if you're told that you're not good at something, rather than saying, well, what can I do to be better, often what you'll find is a tendency to just say, well, I'm going to go do what I am good at. Well, what does that mean when you're 21 or you're 25? Well, then we have sort of calcified our ways of coping in the world. So that means that by the time we're adults, we're often, even if we have information deficits, we don't really have many of us don't have an interest in gapping that in and figuring out the information. Rather, it's, well, I'm going to go do something I'm very, very good at. I'm going to go play Fortnite. I've mastered that. That's going to be my thing. And I'm not sure about, initiatives going on in my jurisdiction. It's just not, it's beyond me. Sounds like it's something for someone else. So it isn't just a lack of information, but a lack of really wanting to gap in that information, because that seems like it's a waste of time, or it's not who we are anymore. So the good news is, one more point that I'm not sure has come up today or has come up lightly is that often if we do feel like we need to go gap in information, the very first place we go is online. And so along with the idea that you have technology at your fingertips and can get an answer in 2 seconds, there is also now the reality that a lot of the information we get might also not be true. So that is a compounding factor. There are things called bots. I think Professor Campbell and I spoke about that online one time, and I wasn't a bot, I was really writing, but it was one of those things where there's information being generated also that is impacting what we see. So even what we think might be verified could be untrue as well. So I think Facebook overnight had blocked 100 different attempts that they thought were Russian attempts to influence the election. So that kind of thing, where there's that type of information coming in as well. So that's kind of the larger picture. When you take it down to being a practicing lawyer, a lot of the things that I think we can do is educate, as has come up today, educate our judiciary, educate our jurors, have an open dialogue about what the picture really looks like. Mark Cohen had said that lawyers must not allow the fact-agnostic court of public opinion to marginalize the judicial process. So we're taking on a lot of responsibility. I don't know if it's in our favor that public opinion about lawyers is at an all-time low. That is just a thing. I actually take that as a great thing at the moment, because that means that we also, if that's already the case, we can decide to be the people who do something about fact deficits. So let's bring it to the law students. What are some things, and some of the things were just beautifully put already by Professor Mullins, so I won't repeat those concepts. But I came up with a few ideas that I thought that we could incorporate into the legal teaching world, so that we might be able to start now. So we cannot go back to being in 5th grade or first grade or anything, but we are here now, and what can we do in terms of recognizing what's going on and what we might be able to do going forward into the profession. So I have written down here solutions, ! And then solutions, ? So here are my ideas, and I would love to hear, and maybe this will just transition us into our questions and answers in general. But here are some things that I came up with. First, I want to frame it as I completely understand the challenges of being a law student and of being completely overwhelmed with information coming at you all the time, being a first-year law student in very, very large classes. I'm not sure how big the classes are at Washburn. At Brooklyn, we have first-year classes that are about 120 students, so very large. And with basically what looks like Greek coming at you, unless you actually speak Greek, and then it's Icelandic. But something coming at you that is impossible to read and takes you 6 hours. So understanding that that is already a burden in terms of what you're experiencing as law students, and assuming that black letter law is the end-all, and also possibly not really understanding what we're doing in terms of teaching fact. So are we talking about facts that can be argued, for example, 2 sides of a legal issue, or are we talking about it is daytime, right? That kind of fact, which is objectively verifiable, unless you're talking about Australia, and then obviously you needed some more information in there. But there are 2 types of fact that we could describe, and so what are we even talking about with that? So already understanding that there is a challenge and that you are overwhelmed, here are a few ideas that I have, and this is actually possibly to the back of the room as well, where the educators are sitting and peppered throughout, but also to the law students. So first of all, professors can model ethics and a set of values for you, and I hope that we do that in the classroom. And it isn't just understanding what the role of our profession is and the fact that we follow ethics, but also things like understanding that when we are teaching you, we value the framework. Somebody had mentioned scaffolding today. That's a beautiful concept. That's actually the idea that we are not just saying, well, what do you think about that? Just tell me what your opinion is. What's your gut reaction? But rather, let me show you how we talk about these things. We're asking questions, we're eliciting answers, but we are in a conversation that has a framework to it. And that actually, so rather than the idea of more speech making this better, I think it's actually more questions. More answer, more dialogue, and expressing that and finding a place for that in the classroom, I think, is really important. Obviously, I will just go very quickly over talking about biases and talking about cognitive theory, because that has been put very, very well today, but that has to be incorporated as well. We have to you have to see it before you can talk about any of these things. I think that there's a lot of value of putting in interviewing skills and negotiation skills really early into the law school curriculum. I'm not sure if people would agree with me in terms of, well, let's just get the fundamentals down. I actually think those are the fundamentals, some of them, because it immediately puts you in a position of having to understand the whole story, seeing things in 360 ways, understanding, walking in the shoes of others and of your clients. It is immediately reframing in terms of the way that you take in information and understand people, and that is, I would offer that immediately, as quickly as one is able to do it in terms of understanding what we do. I also think in the advocacy context, I definitely echo what Professor McMurtry-Chubb was saying, that the understanding things from both sides of an issue is extremely important. Often we do that when we write briefs or we have oral advocacy exercises, but to really understand, you need to unpack what's happening on both sides of the issue. So taking time to fully understand. We are not just like, well, you know, that seems fine, but my side is right. Well, that's called bias. You still, obviously, you have to come up with the most persuasive argument, but you need to see that that is exactly what we're talking about when we're saying you're dismissing what might be relevant and important in the other side as well. Professor Lawrence Solon wrote an article called 4 Reasons to Teach Psychology to legal writing students. That one it's not only on cognitive issues, but it's basically it's got a lot of ideas that basically say that we need to move stuff earlier and we need to have students experience these things quicker. He says it's essential to teach students to take the opposing argument seriously, often requires them to fight the tendency to discount counter-arguments as well as the consequences. So the last thing that I would say is that we should also ask our students as soon as schools kind of begins and what kinds of things would be valuable in terms of, not necessarily curriculum, because I know those things are set the year before and all of that, but in terms of the kinds of things that would be useful for them. Do they need more things in which there are, round tables or colloquia or smaller group projects in large classes? If that helps, then I think it's worth the effort to revise or to at least offer these opportunities. So those were my ideas. I'm going to sit down, but I would love to hear in the question and answer if any of the law students in particular have really great ideas, or the educators, or really anyone who's here. Okay. Thank you.
Thank you so much, Professor Kanwar. I have thought of some questions I could ask, but this event is really about the students, so I'll follow up with those later if we have time, but I'd like to open the floor up to the students right away following on Professor Kanwar's invitation. What questions do you all have? You've got some of the greatest minds available on this topic right now, and you're going to be out there soon representing people whose stories are not yours and who you're going to have to learn to try to understand as best you can and communicate their stories to the court or to other parties. So please take advantage of this chance. I'll bring the microphone to you.
I'm not a student, so I'm already breaking the rules, but I'm going to give you a few minutes to think while I am talking. Patricia Judd, I'm a faculty here at Washburn. Thank you all for your presentations and for your contributions to today's symposium. One of the areas of research that I'm starting to get into is the effect of media on our concept of cultural bias, cultural connection. And Professor Kanwar, sorry, it's weird calling you that. Sorry, it's not weird. Anyway, she's one of my friends. Professor Kanwar, you touched on this concept of gaps in information and how we go towards filling gaps. And several of you kind of touched on the media and the lens and the bias. I wonder if any of you can speak more broadly to the effect of this age of instant gratification, and not only the concept that not all of the information that you're getting when you're going to seek it out is true, but also the premise that you should have an answer and a ready, pat answer immediately. That this should be an easily answerable question, and how that's impacting legal thinking and legal teaching in our current age.
Great question. I will start, and then if anyone on the panel wants to jump in. So I think one of the things that I'm not sure has come up today is that the way that law students now and people in general get their information is in new forms, so social media style forms, just little blurbs that capture just perfectly that kind of thing that you want to say, and that is true, and I'm not sure what the effect is exactly. I think maybe from an even legal storytelling perspective, there's something there, but I think that it has not gone unnoticed that the response seems to be the wave, and the methodologically sound sort of 2-day later response is it's way too late, basically. And so that's the expectation in terms of, probably not entirely in our profession, but in general, that information needs to be captured in a phrase and sent right back out. I think that that is probably having an impact.
Okay, I'm going to take the whole mic here. Okay. I think part of this comes down to law student training. So one of the things that that I do with TAs and RAs is I train them to, whenever I give them an assignment, to resist the urge to say, "Oh, sure, professor, like totally, I can take it on," and say, that sounds really interesting. Let me think about it, see what's on my plate, and I'll get back to you. But it's those habits of thoughtful waiting. And the other facet is, this immediate access to hordes of information is essentially diluting expertise from students all the way on up to Supreme Court justices. And again, better input equals better output. I think we need to improve our education in critical reading, right? We pack so much into the 1L curriculum that a lot of times we just, assume that students will, figure out critical reading like after half a class period and then just go read and practice being critical readers. It's a learned skill, and I think better instruction on how to be a critical reader is one way to combat the effects of the instant gratification information age.
I would say I embrace it. I'm vulnerable, so when they come in my office and I remember a couple weeks ago I was firing off this fire email to a listserv that I was going to then put in my saved folder like Abraham Lincoln and then not send it, but I just needed to write it. And a student came in and they're like, "What are you doing?" I said, "I'm writing this email because I'm angry, but I'm not going to send it." And so we had a discussion about that. And they were like, "Oh wow, I never understood that was an option." The other thing I do is I do this presentation based in Breaking Bad on Jesse Pinkman and Walter White, and my question is, why can't Jesse Pinkman make methamphetamine that is almost 100% pure like Walter White? And the answer is that Jesse Pinkman is following a recipe. Walter White is a chemist with a PhD in chemistry who has a specialty in crystals. That's why he makes the purest meth, and he's Heisenberg. So they begin to understand, I can follow a recipe, that doesn't make me an expert, and that there are pieces of expertise that are needed in order to arrive at a certain level of competency.
I would just say that I think that cultural training towards instant information can be a challenge when we're teaching legal research, right? And even for me, sometimes I go on to Westlaw and I'm thinking, why is it taking me so long to find this? It should be easier. And it's something that students chafe against initially in legal research and writing with their first assignments, that they think it should be easier. I'll comb through 100 hits. I'll comb through 200 hits looking for what I'm seeking. And sometimes you actually find gems that way. And it's tricky because there is a balance. There is that cultural expectation that, hey, we've got deadlines. At some point, you've got to get it done, and it just has to go out. And so you learn techniques for how you can try to get at it more quickly. But I think we always want to back away from feeling as though we got it instantly, because sometimes what we think may be the answer is not.
Can I ask a question? I know that's terrible, but should we do questions first? Yes, I didn't see any hands. Sorry.
question is, I've never taught legal writing, but I have taught an upper level writing course where I often get students citing sources, and I say, do you really think that's a reliable source? Do you think that's a source that you should be using here? And so, how do we teach students to interrogate the source of the information that they're relying on?
Can I take that one?
This is exercise I've gotten during grading.
Okay, so I actually do upper level writing papers with students sometimes. And a couple of years ago, I had this really bright young woman who was working on a paper with me, and she cited to Samantha Bee as I can see circumstances in which you might cite to her as an example of comedy or something like that, but she cited to Samantha Bee as a source for facts. I was like, look, I enjoy Samantha Bee too, but you've got to come up with a different source for facts. And more, I was finding that my research assistants also, I would send them out to get me some information that I knew was out there, and they would come back with articles, but they were just not the sources that I wanted to be using in my law review. And so I actually assigned to them to come up with a hierarchy that was their first task as research assistants, was to develop a training guide on hierarchy of sources. It's sort of getting back to, who was it earlier who said you could give somebody a stack of medical information and that would only push them the other way. Instead, if you give somebody the task of, we'll figure out how this is done properly, and since then I've been getting much better sources from them. So I think it worked.
Okay, Catherine, I have a question for you.
Okay.
I'm sorry, you guys, but one thing you said was really inspiring. Teach people how to label tactics and techniques, right? I think that takes a lot of courage, particularly if a tactic or something somebody's doing is culturally distasteful, like a racist remark. How do we teach law students how to have the courage to label, particularly when they're going to be sort of, they're going to be the small dogs right when they graduate? How do we do that? And everybody, how do we do that? Because that's something that has confounded me.
I mean, with me, I teach them the persuasive techniques, certainly, and then sometimes if a problem invokes it, we do talk about something like, you want to choose the best strategy in your defense, like watch out for victim blaming. We had, about a year ago, I did a false imprisonment hypo. And it was this guy who was visiting a comic book shop, and the comic book shop owner lassoed him with a Wonder Woman lasso and what have you. And there were some things in the facts that, he was wearing a comic book t-shirt, and he did this or that and the other, meaning that he wanted to engage in a live action role play. He was asking for this. And so there was that temptation to victim blame, and we talked about that, and we talked about how to address that. And I think we did talk a little bit on the other side, the people who were advocating on behalf of the man who was alleging false imprisonment, to label that technique as victim blaming. I think it's a little bit easier when it's a client, as opposed to you're in an argument with someone and it's about you and your own stuff. It's easier to stand up for your client and say, you're trying to gaslight my client regarding the facts, or you did this to my client and now you're trying to normalize this behavior. So maybe having that lens there, where it's a client as opposed to it's about them and their stuff is on the table.
I love the idea of bringing in cognition as a more explicit subject in law school. I think if we were designing law school from scratch, of course we'd make it a core part of the experience the same way civil procedure is. But I'm curious how you see the downsides of that and then we're teaching practitioners and not academics. So if a social scientist teaches non-replicable studies or wrong ideas that haven't been fully developed to the proper graduate students, that's part of the process. They go on to develop the science, and it's just part of the process of learning more, learning better. If a law school teaches an incomplete idea or a wrong idea about cognition or empiricism or persuasion to 3 or 4 years with practitioners, that has significant real-world knock-on effects. So what are the obligations that you would have as academics to vet and verify ideas? Would you be comfortable teaching the state of the art? Would you wait a few years for ideas to be really vetted and replicated and tested in the academy before you start teaching the practitioners?
This is something that, as an interdisciplinary scholar, it literally keeps me up at night. It gives me heartburn. I don't have a PhD in cognitive psychology, so what do I do? What would I suggest that law schools do? I think, until we have legal academics who are also expert in cognition, true experts in cognition, as researchers, I think you have to look to people who have been held out as experts within that field. So, there's a reason that I relied on Robert Cialdini, right? He has done extensive work, in selecting his work to rely on and to give a backbone to a lot of my own scholarship. I checked with a lot of different psychology PhDs, like who's a turnkey and who's not. And Cialdini kept coming up as, you can rely on him. And that's really problematic. I recognize that there are flaws in that as well. We might not do it right. But I don't know that the risk of not doing it correctly is worth not doing it at all.
Yeah, and I'd like to push back on the idea that we don't already teach flawed reasoning throughout the whole 3 years of law school. I think we do. And that hasn't stopped us. So I would say that moving with intentionality, and many of us are interdisciplinary to study the things that we're attempting to teach our students. But if I gave, all of you like $500 and had you sit in a law school that wasn't yours and, to interview the students and say, so what did you learn about this? I'm sure we'd all have problems with how you were being taught, what you were being taught, and what kind of unexamined assumptions you were making and how it influenced how you looked at the rest of law school. So I think that, we have to make a start somewhere. We have to introduce the concepts. It's not an either or thing. It's just, we just have to be more intentional about how we integrate it in the curriculum. But I don't think the question is if, I just think it's when.
The last few minutes that we have remaining, I would just like to pose one question to the panel, which is kind of a big picture question and maybe some inspiration for students who will be leading today and maybe letting these thoughts percolate in their minds. One of the hardest things probably about learning to not just in terms of advocacy, but just in terms of understanding our clients and where they're coming from and trying to figure out the scope of their representation. What is it that they're asking for? What are their goals for whatever legal problem we're trying to help them solve? When we're working with people who have a different experience than ours, whether that may be because of race or ethnicity or religion, or maybe just a different way that we grew up in a different kind of community,
learning to recognize our own biases can be a very uncomfortable process. And it can be scary. I know for me, when I finally realized the scope of it, I had to go through all the stages of grief, and that took years. All of it. The denial was the long one, and then there was a lot of everything else. So what are some of the ways in which you all have challenged yourselves to undertake this great life's work of learning to build empathy and openness to other people's experiences, and learning to view problems and the truth from multiple angles? I'm hoping that those stories may help our students to see that it's work they can undertake as well.
I actually taught an affidavits PRI. We have these things called practice ready institutes at Berry that are short intensives. And one of the things that we worked on there is we did a lot of active listening exercises where you just slow down and repeat back what the other person is saying and ask a lot of open-ended questions, because the goal is to really hear their story out and get all of the details of their story. So I would say that's one way to start building empathy. As lawyers, we're used to talking, maybe do more listening.
I think one of my favorite jobs I ever had is I used to work at this hippie college. And it really was for my hippies. The question that I got during my interview was, "Who are you?" And it took me aback because no one had ever asked me that in an interview ever, right? And I was like, "Well, okay, these people are deep." And so what I realized in that was that you have to. For me. People say, "What do you teach?" And I say, "I teach young adults." Like, it's not the subject, it's the people. And in order to connect with the students, I have to know who you are, and I have to show you who I am. And then we can have this conversation. So when you're coming in my office, you're not just the person who's enrolled in X class, you are the person whose grandmother may have just passed away, or you just broke up with your partner and you're devastated, or you really don't want to be in law school, but people are telling you you need to be there. And understanding what impact that has on how you're willing to understand what I am telling you, trying to convey to you. A quick anecdote, I remember when I moved from LA to the Deep South, culture shock, and it's not that I hadn't lived out, I lived in Atlanta, which is not really the South, then I lived like literally in Georgia. And I remember I had these slides up because I teach the Shuttlesworth case, and when we're talking about like deconstructing an appellate brief and the Good Friday March. So I had these images of the marchers and protesters with Confederate flags. And in California, my California kids were like, "Dude, that's bad." And then I get to the South, and I remember the first time I was showing these slides, and it was like this realization, like, you are not in California. And I had a front row of like all white male students, good old boys, and the first thing they said is like, "First thing I see things, we're a bunch of racists." And I was like, "Oh my gosh, I really don't think you're a bunch of racists." So we have to talk about this. And what I have found is that the way that I teach and who I teach, like my white male good old boys ride hard for me. Like if someone says something for me, they're like, "Well, excuse me? You talking about President MC?" And this is huge. So it's not to make these assumptions about what someone believes based on how they look or how they come off to you, because there's a whole person in there that's complex, that has had these experiences, and to try to understand who they are as you understand who you are too.
So for me, this comes back to driving. And several years ago, my husband and I lived in Eugene, Oregon, where no matter what the speed limit is, like, everybody's going 20, okay? And, so we left Eugene and we were in Grand Forks, North Dakota, where people did not go 20. Now we are in St. Petersburg, Florida, and people are, like, you're taking your life in your hands when you get on the road. And my husband, who is generally unflappable, it makes me insane, right? And it's terrible to be in the car with him. Like, I feel like my blood pressure rising. and people cut him off, and the thing that I've said to help him, and this is what I've said now to help students, just in terms of basic mental health, is just make up a good narrative about it, right? That person cut you off. Well, maybe that person's kid is having an asthma attack. We've got an asthmatic kid, and they need to get to the emergency room, right? Chances are that's probably not what's happening, but it makes you feel a lot better when you can construct multiple positive narratives. But I think that comes into play with building empathy in clients who may come from very different circumstances than you come from. So when a client does something or says something, or that doesn't connect for you, kind of coming up with a variety of different explanations, I think, and if it doesn't matter, going with the most positive one, I think is at a minimum. I think it builds empathy. I think it also preserves mental health.
So there are a couple ways. One is, so in the law school setting, I think we have a lot of the luxury of, even though I said there's so much to do and it goes so fast, we do actually have the luxury of time. So I think that one of the true joys of my life is being a mom, but also having my law students and getting to know them really, really well in the first year. And then they keep coming back, and so that is an amazing thing. So I feel like trying to build in opportunities for the students to get to know each other, and not on things like, how would you look at these facts, but let's do things together that make you just see each other as humans first. And maybe that is to one of the earlier presentations talked about doing things in a collaborative way that are of your own. So basically, we're all in it together. So that kind of mentality in a classroom, I think, is really, really positive. And that actually, we had a whole thing, a presentation, or an entire year of doing diversity initiatives at our law school. And what we found out is that people just needed to have a chance to hang out together. And not in a way like, why do you think the police are this? And because that is already polarizing, and it's already putting people in camp. So that's number one. If we can find those opportunities and those places to build empathy that way, it automatically happens. So there's that. I think in terms of having clients, you often don't have time. Like, you don't have an entire year to get to know each other. So I think in that way, going to where, if it is possible at all, my husband is a legal aid lawyer, and the way that he works with his new attorneys is the very first thing they do is they go to see the clients in their homes, because they do tenant protection work. And so just don't have them come here, come to the office and already be out of their element and feel like outsiders. You go to them. And so that, all of that is, and I think it's like someone who said, if you take people and you put them in, was it Teach for America? Something like that. If you go and you're in the place, there's no way you can't be impacted by that. And it isn't sort of making you choose anything. It is just showing you what they're experiencing. So that I think is the best way.
That's a perfect note to end on. Thank you so much. Thank you so much to our panelists for coming and sharing.
Yeah, you just stay. I think I wanted to just take a couple minutes to thank a few people who made today possible, and then we'll be done for the day. First of all, a thank you to all of our presenters and speakers for traveling to be here and facilitating such great conversation that I think will be continued to have here. We will continue to have these great conversations over the next weeks and months and years, and both here and across the country as people travel. So thank you so much for that. I wanted to thank Caitlin Allegria and Casey Scott for helping with a lot of last-minute details and helping drive people back and forth to the airport. Also, Gabe Greenbaum and Colin Halpin helping drive people back from the airport, and for helping come up with some of these great topics and panel ideas and keynote speaker ideas. Noelle Blood and Sheila Summers, who helped with a lot of the marketing, getting this, which helped with the great attendance we've had today. Martin Wisniewski helped with that as well by setting up the website and as well taking photos today so this can be memorialized. Also, Glenn Macbeth for helping to set up the video and a lot of the technology today. And Brooke Schmidt and Blake Porter for live tweeting this event too. So for those who couldn't be here to follow along on the Washburn Law Journal Twitter, a big shout out to Professor Kowalski for not only moderating this panel, but for helping. I think almost everyone on this panel is here because of our connection with Professor Kowalski, and it means a lot. And all the Washburn Law faculty that reached, and administrators that reached out with ideas for who to invite. Everyone that is in attendance, I really appreciate. I know our time in law school and in the legal community is one of the most valuable things we can give, so it means a lot that you took the time to be here today. And then Audrey Kaler, our senior articles editor, who I think is in a class right now, but pass along to her thanks. If you see her, she was on top of the Symposium committee, helping us stay organized. She is responsible for Donna Vilander and Dean Leisinger. Anything going smoothly today is because of those three and their great organization and their ideas. Audrey's ideas for how to market this among students, and some of the panels to come up with as well, doing a lot of the research on who to invite, and Donna and Dean Leisinger's constantly giving us, using the wisdom they've come across from the past years of doing the symposium and helping it to run as smoothly as it did today and has over the past few days. So thank you for saying for the thank yous, and thank you for coming today, and we've been happy to have everyone here, so thank you. Oh, and thank you to the Ichabod Shop and the Washburn Alumni Store for donating some gift cards that are going to be used in student raffles for law students that attended today. So thank you for that.